And good morning and welcome to an oral argument session of the 5th District Court of Appeal. This is the 10 o'clock time slot. We have the case of Frontline Insurance Unlimited Company et al. Versus Beckman Atlantic Funeral Homes and Crematory Incorporated. On the panel with me today, my name is Rand Wallace. I will be presiding today, and we have on our panel as well Judge Eric Eisnagel from Seminole County, and our newest judge, Judge Carrie Ann Wozniak. Want to welcome Judge Wozniak to the court, and we're excited to have her join us on this court and working first in our first day of oral arguments. So, Mr. Levy, I'm going to assume that you want 5 minutes of rebuttal unless you inform me otherwise. And I would just ask everybody to make sure that if you have any devices that would make noise, that you put those on mute so it doesn't interrupt the presentation by the lawyers. And Mr. Levy, you may begin.
Thank you, Judge. And 5 minutes would be perfect.
Okay.
May it please the court, Jay Levy on behalf of Frontline Insurance. This case is an appeal from an order awarding attorney's fees. The issue before the court is not the underlying award of fees. It's the award of a 1.9 multiplier, and specifically the award of a multiplier at all. This case was described by opposing counsel in his testimony before the court at the attorney's fee hearing as being a straightforward case, and you'd find that it's 738 of the record. The elements of to be awarded a multiplier are threefold as defined by the Supreme Court in Quanstrom. The first is whether the relevant marketplace requires a contingency multiplier to obtain competent counsel. The second is whether there is the ability of the plaintiff's counsel to mitigate the risk, and the third are the Roe factors and whether they play into the award of the attorney's fees. It is this court has established, along with others, but this court specifically in its Progressive versus Schultz decision, established that the first factor, whether the relevant marketplace requires a contingency multiplier to secure competent counsel, is the most important factor. It is the position of Frontline before this court that the testimony is entirely lacking before this court, that there was no evidence adduced, and indeed no finding made by the trial court, either orally at the end of the hearing or in the final judgment, that the relevant market required a contingency multiplier to secure competent counsel.
Did you challenge the lack of finding?
I'm sorry, go ahead, Judge Eisnagel.
I was just going to ask about the finding. Is that required, and did you raise that in a motion for rehearing?
Well, this was a non-jury decision, so no motion for rehearing, as I understand it, Your Honor, is required. It would be different if it was a jury trial, in which case you would have to file a motion.
Well, you're talking about whether there's substantial competent evidence, right?
Well,
I'm asking you about, counsel, I'm specifically asking you about the lack of a finding.
No, there was no motion for rehearing as to the attorney's fees.
No. As to, you mentioned there was no finding by the court on whether a multiplier is required. Isn't that what you just said?
Yes, sir.
Okay. So my question is an express finding required? Are we required to reverse if the trial court does not make an express finding on?
I think that both are required. Both, there must be evidence and there must be a finding.
Okay. And so then my second question is did you raise the lack of a finding on rehearing?
We did not file a motion for rehearing as to the attorney's fee award. We took a direct appeal.
Okay.
Okay. It is our position that, to quote the 3rd District, in a case by the name of Despain, which, although only appears as a Westlaw site, is a final decision as the mandate is issued. It said the plaintiff's fee expert failed to testify that the Despain's counsel was the only competent counsel in the relevant market, nor did the expert alternatively testify that while there was other competent counsel available in the relevant market, they would not have taken the case on the simple contingency fee and would have done so only if the multiplier was available. There is no testimony in this record from Mr. Struble or his expert that either one of these elements was present. There is testimony on the other hand, and let me point
Counsel,
out.
first of all, the expert that you offered, let me just make sure I'm clear. That's not really relevant to the appeal because we're just looking at whether there's substantial competent evidence, correct? You're not asking us to reweigh the evidence, right?
Absolutely correct.
So we don't need to focus on whether the expert you offered sufficient testimony, correct?
You're right, except I would disagree only in one instance. What my expert testified that the relevant market is statewide because these lawyers come from all over the state. Indeed, Your Honor, I'm sure that before Your Honor, in cases that there have been lawyers from all over the state that handle these kind of first-party insurance cases. But I agree with you that in concept, this case stands or falls on whether the plaintiff offered sufficient evidence to justify the use of the multiplier. And no, I am not asking this court to reweigh. I am not arguing that this is contrary to the manifest weight. I'm saying there's no evidence to support.
Well, counsel, your initial brief at page 12 says that, and I'm somewhat paraphrasing this, but Struble testified there's no way to take a $17,000 case without a multiplier. That he testified to that. Is that accurate?
He did say that, but the test is whether or not there are attorneys in the relevant area, in the relevant market, that would take the case on a contingency, without a contingency. That is, I'm sorry, that there must be attorneys in the relevant, no attorney in the relevant marketplace would take this case without the contingency multiplier. That Mr. Struble would do it is an interesting fact, but the cases that I've cited indicate that that's not enough. Well, specifically, this court's progressive decision.
Right. No, he didn't say he couldn't do it, as I understand. I mean, your initial brief, the way your initial brief presents it, he testified that there's just no way to do it with a $17,000 case. That would seem to apply generally.
No, I don't. Respectfully, Judge, I disagree. The testimony here would have to be that I mean, if you go to the Joyce decision, the expert testified that he went and talked to other lawyers to enforce his opinion that there was no lawyer that would take it on a contingency fee basis. Mr. Struble testified that he would not take this case that way, that there was no way he could do it because it was a low item, meaning only $17,000. He did indicate, though, that he took the case because he would get his full hourly fee based upon the $627,428, the statutory fee. But no, I disagree, Judge Eisnagel, with regard to the concept that he was testifying across the board. That's not a reasonable reading of the testimony. And nor did the judge found. What the judge found in paragraph 8 of the final judgment was that the court found that the relevant marketplace supports a multiplier. The court is familiar with the work and reputation of Struble, PA, and there is a dearth of first-party attorneys available in Brevard County with the amount.
So if I could just
yes, Your Honor,
challenge you. These are your words, counsel, out of your initial brief. Struble contended that without a contingency multiplier, an attorney could never file suit over a $17,000 dispute because it would be economically infeasible.
That's what he testified to. But
how is that? He said an attorney could never. I mean, how is that not a general statement as opposed to him saying his firm couldn't do it?
Well, if you read the sum total of his testimony, that's what he's saying. He's saying that his firm could never do that because of the because it was $17,000. Okay. On the other hand, Judge, he did say that he would be compensated in full for the hourly time that he did because of section 627-428, and which he did, and we don't challenge that particular fee. I will during the when Mr. Struble speaks, I'll look at the specific reference in the record, and so I can bring that back to you as to the specific testimony.
A general question: does the availability of statutory fees play into this prong about the relevant market requiring a multiplier? Because there are fees available, obviously, statutorily in cases like this. And I'm just wondering how that interplay works.
My understanding is the purpose of the stat fee of 627,428 is different from the purpose for the contingency multiplier. The 627,428 fee, Judge Wozniak, is to make sure that counsel that the underlying fee is paid for where the insurance company wrongfully denies the fee. The purpose of the multiplier is to make sure that competent counsel is available. So it's not exactly the same. There are cases, and I think I cited one in my reply brief, that talk about the fact that may go to the ability to the second element, the mitigation of the risk, because you know that if you're going to win, you're going to get the fee. Okay, but it's not necessarily exactly the same concept. I hope I've answered your question.
Yes, thank you.
Okay, so Struble testified that that he would never take a case like this unless he could get a contingency fee multiplier. But what Mr. Struble would do and how Mr. Struble would handle the case does not address the issue of whether there are other lawyers in the relevant marketplace that would take the case. The only witness who testified as to that was our expert who identified specific lawyers who would be available that had a statewide practice that would handle these cases regularly without a contingency fee multiplier. And so that was the evidence. The judge's reason in the order that there was a dearth of first-party attorneys available in Brevard County with the amount of trial experience is an interesting finding, but that does not mean that there were not other competent lawyers who can handle it. If I could give the court a very, very poor analogy, if you wanted to paint your house, you get a house painter. But the fact that Van Gogh may be able to paint your house does not necessarily mean that you need Van Gogh. You just need somebody competent to do it. The fact that Mr. Struble has more trial experience than other lawyers is a factor, but it's not the only factor. It does not equate to the fact that there are not other competent counsel that are available. And indeed, I have cited several cases. The one that I think is most persuasive to this court is its own decision in Progressive Express Insurance v. Schultz, wherein this court said, quote, "Common sense also plays a role here. We are not so isolated from the world around us to know that few people have any difficulty retaining competent counsel in these circumstances. Our docket and the dockets of the trial court in Central Florida have hundreds and perhaps thousands of PIP suits pending at any given time. It seems that few insureds have difficulty obtaining competent counsel to represent them." Now, that was a PIP suit. I understand that. The federal courts in three cases I've cited in my reply brief, apply that logic to first-party insurance cases and hold in first-party cases that that the same logic applies and that their dockets reflect, and the dockets of all the courts reflect both throughout the state of Florida, that there are many, many lawyers available to take these cases. This was not a complicated case. This is not as necessary your run-of-the-mill first-party case, and I say that only in the sense that this was a case over whether we properly took a $17,000 deduction. We weren't arguing coverage. We weren't arguing amount of loss. It was solely a deduction question, and it was
raised 12 affirmative defenses and litigated the case for a year and a half, correct?
Judge, the litigating of the case for a year and a half is kind of irrelevant in the sense that it's a 500-page record. It's not small. It's not a large record. There were no depositions taken, no motions for summary judgment, written discovery only. And the fact that it took so long to get to trial is the function of the trial calendar more than anything else. And I would point out, Judge,
what about the hours that the Struble firm spent? You don't contest the number of hours on.
No, Judge, we have not appealed that at all.
So over 100 hours, as I recall, spent on the case. That's so. Would that be a better measure than the year and a half?
He said that most of the time spent, his testimony was getting ready for the trial, and we paid the money prior. So I don't know.
Right before trial.
Yes,
you
sir.
Let him get ready.
And we paid. And we
when
paid
you was going
every
to trial. You paid. Yeah.
And we've paid every cent for the attorney's fee on that. But I wanted to go back to your
And you
question.
stipulated right after you settled the case to the entitlement to attorney's fees, correct?
Yes, sir. We've never made an issue of that. We did present other evidence as to what a reasonable fee would be, but there's competent evidence to support.
Counsel,
what
when
the ju-
Strubal's looking, when any firm is looking at your defenses, 12 affirmative defenses, I mean, I think this panel is going to assume that all of those defenses had some merit, that none of them were frivolous.
Judge, I didn't do this answer. You'll find the answer at 69 to
Well,
76.
let's just start with that. I mean, do you agree that all 12 had at least some potential merit from?
Respectfully, no, I don't.
Oh,
Okay, in all candor, I don't. In this kind of a case, arguing that there's comparative negligence and there should be a percentage reduction is with no disrespect to my prior counsel, not me on this one. It's silly to argue that they
so
should.
how many of the counsel? How many of the defenses raised would you say were frivolous of the 12?
I hate to use the word frivolous because it throws my prior counsel under the
bus. That was my question.
I'd rather say meritorious.
Either they had merit, or they potential merit, or they didn't. Right. So
the only one that I can see that I would have raised as a meritorious defense is number 2, that there was an issue as to whether all conditions precedent had been complied with. Okay. Everything else to me, third parties are responsible. The company acted in good faith. That there was no damage as a result of the alleged actions, that they're not entitled to court costs. I mean, I can go down the line respectfully. I think that facially on their face, they were really not a problem. I'm sorry that my prior counsel raised 12 affirmative defenses, but Judge, when you go through these things and you've been doing this a while, you can sort out the wheat from the chaff. Judge, am I into my rebuttal time?
You are, yes.
Okay, then I would just like to wrap this up by saying that there's got to be evidence that in the relevant marketplace, no competent lawyer, without a contingency multiplier, no competent lawyer would take that. This court can look at its dockets. There are ample lawyers around to take that, and no one has said that there was no lawyer that would not take this case without a contingency multiplier. I thank you for my time, and I'll reserve the rest of my time for rebuttal.
Mr. Struble.
Good morning. May it please the court, Matthew Struble for the appellee. All of the arguments presented by the appellant in this case predate this Florida Supreme Court's decision in Joyce versus Federated National. And Joyce versus Federated National made it explicitly clear that what the court looks to is the relevant marketplace. And in that case, the relevant marketplace was St. Augustine County. And the defense's arguments that there was courts, other lawyers in other parts of the state, including Duval County, that would have handled the case, was specifically rejected by the Florida Supreme Court. And that's the only argument that's been made by the appellant on this case. And the issue here is whether the trial court's findings were based on and supported by substantial competent evidence. And they were not just as to one factor, but to all of the factors for the court to consider. The court explained it was aware of our firm's work and reputation. It specifically found there was a dearth of lawyers that handle in Brevard County.
Counsel, if we could just focus at least initially here on whether there was substantial competent evidence regarding whether a multiplier was required. I've already referenced your testimony on page 787, where you said, I'm sure, responding to the questions about the multiplier, because otherwise I'm sure you could never file suit over 17,000. It would be economically infeasible. Is that sufficient, or is there other evidence in the record that would be substantial competent evidence?
Judge, I would say that testimony is sufficient. If you look at the Joyce versus Federated National decision, in that case, the Florida Supreme Court referenced and relied on the insurer's attorney, saying that at the time they took the case, they took it only because there was a chance to obtain a multiplier. And actually, I believe they actually used the words economically feasible in that case as well. That's the same testimony that I gave at the fee hearing. It was unchallenged by the defense, and that testimony alone is sufficient to support it. We did have expert testimony.
I guess your opposing counsel is kind of saying, hey, look, that's not sufficient because he reads it as that's your testimony that your firm would not be able to take it. But that's not quite what you said. That you said, quote, I'm sure you could never file suit over 17,000 because it would be so can we read that as more of a general statement that, in the area, lawyers generally can't file suit over this
Yes,
small?
Judge, and I think if you look at my surrounding testimony, I was explaining why no firm could, because 17,000, if we were only limited potentially to the contingency fee amount to that, it was apparent we were going to have to spend 100 hours, retain experts, put a lot of time into the case. I think I went on to explain, in order to handle a case like that, you have to have staff assisting with the case. And I explained how it's impossible for a firm to handle a case over $17,000. And I think that's the exact reason why the courts have allowed for a contingency fee, because otherwise Frontline could do what it did in this case, but for having to pay at the end of the day. They could say, hey, it's only $17,000. What are you going to do about it? It's not worth your time. And we're just going to raise 12 affirmative defenses and deny that we owe everything all the way through the case, which is what exactly happened here. And in order to have a chance to actually pursue it and overcome those things, I think that's the exact reasoning why the courts have said that a trial court needs to be given some flexibility to analyze the case and determine whether the facts of the case required a multiplier in order to encourage a lawyer to take this case. And as I explained it in the testimony, you need that type of encouragement in a case like this, where the amount of dispute is $17,000 and they are refusing to pay it, and then raising 12 defenses and standing by those up until the day before trial is set to commence.
Counsel,
So
on the defenses issue, I mean, your opposing counsel, as I understood it, conceded that the lion's share of those had absolutely no merit whatsoever. I think the implication is that you should have been free to ignore the lion's share of those affirmative defenses from the very beginning. What is your assessment? I mean, I looked at them myself, and certainly some of them seemed to not make a lot of sense. How many of those affirmative defenses would have been actually, really truly in play?
Yeah, so I mean, kind of my response to that would just be that, I wish they told me that then. So for example, if they raise an affirmative defense, that's something I have to disprove. I think we would have disproved them, but just to give you an example, the one that they say, hey, there's no coverage at all because the damage wasn't caused by the hurricane. To me, I don't think that's supported by the evidence, but still at trial, my job is I have to put on all the evidence, be ready for them to call experts saying, actually, we think it was all pre-existing, which does happen at times. Be ready for a charge conference where they're arguing to get that question on the verdict form. And if they get that question on the verdict form, I could lose the case in its entirety. So I think that's, a good example here. I don't think they would have prevailed on that particular defense, but it's something I had to have experts lined up and ready to testify at trial, and evidence ready to test at trial to meet my burden as the plaintiff, and then get to, the charge conference where we would argue the jury instructions. So, I think that I do agree that some of them, I don't think carried much weight, but by the fact of them asserting them, I had to be ready to defeat them. And if you look through, really, if you look through some of the testimony throughout the evidentiary hearing, they were suggesting that, I should have somehow won the case easier. I should have filed motions as to their affirmative defenses. And, what they're suggesting to me is that I should have filed more motion practice and more hearings and spent even more time on the case, where, I think as we put forth, and I think the trial court agreed that, in this case, I didn't take depositions. I didn't overwork the case. I just tried to get it to trial as quickly as possible, because that appeared to me to be the only way we could get them to pay the case. And that's ultimately what happened at the end of the day. And I think that's why, obviously I'm guessing, but the court, focused on the trial experience that we do have when it determined that a multiplier was necessary in this case and decided to award it. So, and when you look at the court's rulings, I would say if you look at Joyce says that the relevant marketplace is Brevard County. Both the trial judge and our expert testified that we're the only firm in Brevard County that has the experience to do that. I gave testimony explaining that plaintiff lawyers in Brevard County, when they have cases, they refer them to me for first-party cases that I've represented plaintiff lawyers personally. So I think there's a plethora of evidence showing that Brevard County is in need of a multiplier to have lawyers that handle cases in Brevard County. And then as kind of a separate issue, the court even went as far as to say that they don't believe that there's attorneys anywhere statewide as kind of a second reason that would have handled the case in the manner I did, which is where I agreed to handle it on statutory fees only. So in the initial case, we recovered about $600,000 for our client, and we didn't take the $200,000 contingency fee. We took approximately the $3,000 statutory fees that were awarded as to that. So there's two separate ways the trial court ultimately found that just as to that first prong, that a multiplier was required. And then if you go to all the other factors to be considered, whether there's ability to mitigate the risk of non-payment, that was certainly supported by substantial competent evidence. I testified to it. I explained there's been instances where a question's been on the verdict form and we've lost all the costs we've fronted for the case and hundreds of hours of time. And that in this case, there was no opportunity to mitigate the risk of non-payment. So you had substantial evidence in this case. It appeared clear to me that the trial judge reviewed that evidence, found that a multiplier was required, addressed Brevard County specifically. And after that order was entered, the defense never took the position, hey, your finding's not specific enough, or you need to specifically rule this way or that way. They never challenged that. They never asked for a order specifically addressing it. But what's clear the court did was it reviewed the evidence presented to it and specifically found that Brevard County required a contingency fee and assessed it in accordance with that. So, based on the court's prior rulings, the trial court's prior rulings that had issued to us, our experts' testimony, my testimony, we think there was certainly substantial competent evidence supporting it, so it should be affirmed. And also all the legal arguments that presented by the appellant in this case have been specifically overruled. All their cases are cited are prior to Joyce versus Federated National. So we think it's very clear based on the Joyce versus Federated National case that the multiplier should be affirmed.
All right. Thank you, Mr. Struble.
Thank you very much for your time.
Mr. Levy.
If I may make 3 points in rebuttal. First of all, I'm a little perplexed because there was no defense of coverage ever raised. And looking at the affirmative defenses, there's nothing that would justify the statement that counsel made. Second, there was no motion for summary judgment ever made in this case, which I find interesting because that would have cut through everything and resolved this case early on one way or the other. Third, the exact testimony, I've gone back and looked at, and this goes back to your question, Judge Eisnagel, question. And by the way, if the client were to pay you a contingency fee for that $17,000, your fee would be limited to like 30%, right? Answer, that's why the factor supports a multiplier. Question, that supports a multiplier? Answer, yeah, because otherwise, I'm sure you would never file suit over $17,000. It would be economically infeasible. But the testimony goes on. Question, because your agreement says that if you filed suit for $17,000, you would then be entitled to seek fees under the attorney's fee statute, right? Answer, and this goes to your question, Judge Wozniak. Answer, exactly. That's what I explained during my testimony. Right. So, and as this court knows, you take the positive recovery. So you recover like $3,000. And there's case law that says if you recover even like $1, you're entitled to a recovery of attorney's fees as a prevailing party. Answer, if I get a judgment, yes, I'm entitled to attorney's fees. And he goes on to say the reason that he took the case originally, and there's another place in his testimony where he says, I took this case because I knew that if I won, I get my stat fee and I get paid for all my hours. We disagree that you need that the requirement that you have an office in Brevard County is not the correct marketplace. It's those attorneys who practice in Brevard County, lawsuits that are filed in Brevard County and in Central Florida. The cases talked about the relevant market. The federal cases talk about the relevant market in Central Florida, in South Florida. They don't limit it to a specific county. And indeed, this court in the Schultz case, which has many, many parallels to this case, talked about the fact that that the relevant market is the docket in Central Florida. And one other thing out of Schultz, quoting the prior opinion of Judge Harris, which it adopted, it must be proved that but for the multiplier, plaintiff could not have obtained competent counsel in the area. Plaintiff counsel attempted to make this showing by himself, testifying that he would not have taken this case without the multiplier. That's essentially what this testimony is. This court held, adopting Judge Harris's opinion in the prior decision, that's not enough. There has to be evidence in the relevant market that there would be no attorney that would take this case without a contingency multiplier. That's what the third held in that recent Despain case. That testimony is lacking here.
Isn't it just that a multiplier is required, not that there's no attorney anywhere, right? I mean, what if there was one other attorney that would take the case, but you know, they have to demonstrate here. Here's the three attorneys that would take it. We talked to all of them. Is that what they have to do?
Well, if you look in the Joyce decision, Judge, and I'm probably going to run over my time for a few, but in the Joyce decision, it said that there was no lawyer that would take the case, that there were a few lawyers in St. Augustine County that handled it, and there's no lawyer. In a recent case, and I forget the name, I think it's AB, that this court decided, it said that there were only 3 lawyers statewide that would handle the case, and there was no one. And if you go back and you look at the 3rd District's per curiam decision, they say there has to be no lawyer. There has to be testimony that there was no lawyer that handled this case. That testimony is absent here.
Well, I mean, again, well, I think we go back to the testimony where counsel says you cannot take this case for $17,000. It would be economically infeasible, right? So the question is was he referring just to his firm, or was he referring to any firm?
I think there has to be specific testimony that no lawyer in the relevant market would take this case unless there was a contingency multiplier. I think he was speaking of himself, and as I just read to you, that is insufficient. And in all of the cases that I've seen where the courts are talking about this, and the most recent one is the Despain case out of the 3rd. They say that the testimony has to be that you must testify that there is no lawyer in the relevant market that would accept this case without a contingency multiplier. That testimony is lacking here. I asked the court to look closely at the 3rd District's decision, which is the most recent one on this point. I apologize to the court for running over my time, and I thank you for your time.
Thank you.